Mike Duffy from Prince Edward Island.
Today, the committee will continue its study to examine the impact of federal provincial laws and policies governing charities, nonprofit organizations, foundations, and other similar groups, and to examine the impact of the voluntary sector in Canada. For this meeting, we will focus on the advocacy and political activity as it relates to charities and nonprofit organizations. For our witnesses, we welcome from the Canada Without Poverty, Ms. Harriett McLachlan, Deputy Director, and Ms. Michèle Biss, Legal Education and Outreach Coordinator, and from the Canadian Bar Association, Ms. Karen Cooper, member of the CBA's Charities and Nonprofit Sector, and Galen Schellenberg, a lawyer, legislation and law reform. I think I've got everybody's name right there. Thank you. And thank you for accepting our invitation. I would invite the witnesses to make the presentation, but I would also like to remind them that as per our instructions, they have been given between 5 and 7 minutes in length for presentation. Following the presentation, witnesses will go to questions and answers from the senators, and we'll ask people asking questions and answering questions to be succinct so we can get as many questions and answers in as possible. Who's going to lead the charge today? Harriet?
Sure. Good afternoon, and thank you for the opportunity to address this committee. My name is Harriett McLachlan. I'm Deputy Director of Canada Without Poverty. I'm joined today by CWP's Legal Education and Outreach Coordinator, Michèle Biss. CWP, formerly known as NAPO, is a nonpartisan, not-for-profit and charitable organization dedicated to ending poverty in Canada. For nearly 50 years, CWP has been championing the human rights of individuals experiencing poverty, and since our inception, we have been governed by a board of directors comprised entirely of people with a lived experience of poverty. This committee should know that though I'm an educated professional, I lived in poverty for almost 35 years, 19 years as a single parent. CWP approaches poverty from the perspective that as a signatory to the Sustainable Development Goals, the International Covenant on Economic, Social and Cultural Rights, and other human rights treaties and agreements, Canada is obliged under international human rights law to meet the rights to housing, food, work, health, and an adequate standard of living.
As members of this committee are no doubt aware, in July 2018, Justice Morgan of the Ontario Superior Court ruled in our favor in the case Canada Without Poverty and Canada, which challenged Section 149.1, sub 6.2 of the Income Tax Act. In that case, we argued that the restrictions on nonpartisan political activities restricted our ability to engage with our members and the public in pursuing our charitable purpose of relieving poverty. We argued that the provisions stifled the voices of people living in poverty to share their experiences, identify the causes of poverty, and publicize recommendations for necessary changes to laws, policies, and programs to relieve poverty. Justice Morgan agreed and said in his judgment that unlike old models of almshouses and soup kitchens, CWP's work to relieve poverty by sharing ideas, achieving attitudinal changes, and engaging in public policy dialogue was necessary for the achievement of our purpose. He determined that Section 149.1, sub 6.2 of the Income Tax Act is a violation of Section 2B of the Canadian Charter of Rights and Freedoms under freedom of expression, and that such a provision was not reasonably justified in a democratic society. He therefore declared that the restrictions on nonpartisan political activities to be of no force or effect, and ordered that henceforth charitable activities must be understood to include nonpartisan political activities in furtherance of a charitable purpose. As we have stated at the Standing Committee on Finance in our submission, we support the provisions in Part 1 of Bill C-86 as it is consistent with Justice Morgan's order. It is also consistent with Recommendation 3 of the Consultation Panel on the Political Activities of Charities, as well as the concluding observations issued by the United Nations Human Rights Committee back in 2015. A backgrounder from the Department of Finance explained that the new legislative provisions will permit charities such as CWP to devote time and resources without limit to public policy dialogue and development in furtherance of the charitable purpose of relief of poverty. In some of the testimony presented by witnesses at this committee, and in some of the public discourse on this issue, it has been suggested that Justice Morgan's decision would open the floodgates for political entities and organizations with non-charitable political purposes to register as charitable organizations. But this could not be further from the truth. We emphasize that the changes instituted by Bill C-86 and by Justice Morgan's decision do not, in any way, allow groups that do not have an accepted charitable purpose to claim charitable status for political activities. Rather, these changes simply recognize that freedom of expression and participation in public policy dialogue are a critical component of the effective pursuit of accepted charitable purposes, such as the relief of poverty. Justice Morgan's decision does not mean that entities with a singular, non-charitable political purpose, for example, as has been brought up, opposing minimum wage, would be able to qualify for charitable status. In order to qualify for charitable status, organizations still need to fit underneath the 4 accepted charitable pursuit headings: relief of poverty, advancement of religion, advancement of education, and or a purpose beneficial to the community in a way that the law regards as charitable. It is important to understand that CWP never argued, and Justice Morgan never ruled, that the Charter requires governments to provide charitable status for organizations to express any views that they wish to do. Governments make decisions all the time to provide tax or other benefits for particular expressive activities deemed to be of public benefit. And CWP has never suggested that the Charter prevents the government from doing just that. In fact, it is quite the opposite. We argued, and Justice Morgan agreed, that the government is entitled to decide what purposes should benefit from charitable status. However, any restrictions on public expressions by those organizations whose purpose has been accepted as charitable must be justified. Muzzling public policy dialogue on issues of poverty prevents charities like CWP from pursuing their purposes as effectively as we can. We will also note that in spite of the fact that the changes in Bill C-86 essentially implement Justice Morgan's order, the government has not yet indicated an intent to withdraw its appeal in the decision in Canada Without Poverty and Canada, and has not acknowledged that the restrictions on public policy dialogue of charities violates the Charter. Justice Morgan's decision should be allowed to stand for its recognition that monitoring the communications and speeches of member groups like ours in order to prevent people living in poverty from publicly recommending necessary changes to laws and policies is simply unacceptable in a free and democratic society.
I'd like to take a moment to ask the committee to consider what the issue means to millions of people living in poverty in this country. At its core, the study in this issue requires us to consider a question: how do we relieve poverty in Canada? Do we do so exclusively through frontline services that address solely the symptoms of poverty? Or do we go further and remove barriers to ensure First Voices on poverty can speak to its root causes and help create solutions based in human rights? Crucial to Justice Morgan's decision was the understanding that the restrictions of freedom of expression that apply to all charity originates in discriminatory and stigmatizing notions about the poor. We have heard from members of our board of directors, all of whom have the lived experience of poverty, and from many organizations and individuals across the country, that this decision in this case represents to them a historic vindication of their struggles for dignity and inclusion. Many have expressed to us that the judgment's recognition of this important role to be played by people in poverty in decision-making, and the rejection of stigmatizing understandings of charitable activity resonates with their lived experience in a way that few legal decisions do. We ask this committee not to forget the chill effect on charities in the context of the large-scale audits conducted in 2012. For our organization, in November 2011, Canada Without Poverty required to provide CRA minutes of all our meetings, copy of all our email exchanges by staff, volunteers, and board members, all our publications, all our communications for a 3-year period. After its investigation, CRA found that CWP members and staff frequently identified changes that needed to be made to laws or policies in order to alleviate poverty, and publicly promoted the adoption of a national anti-poverty strategy. CRA also found that some of CWP's activities related to the promotion of human rights created an atmosphere conducive to advocating for changes to laws in poverty. These activities included: 1. Hosting a dinner where people living in poverty ate a meal with members of Parliament and other decision makers and discussed their experiences of poverty and ideas about how to address it. 2. Organizing policy summits where people living in poverty could collaborate with social policy experts and academics to develop recommendations for addressing poverty. And 3. Offering an online course on Canada's obligations to address poverty under international human rights laws, where people living in poverty could join a community of learners to discuss topics of the day. These activities are all considered political by CRA. Our organization relies almost entirely on donations, and we would likely not be able to survive if our charitable registration were to be revoked. You can imagine how upsetting it was for our members and staff to think that their critical voice in Canada's democracy might be silenced simply because they had publicly discussed ideas about what governments could do to relieve poverty. In fact, for us, our audit process has not officially concluded. Upon our last correspondence with CRA, their decision to withdraw our status is on hold, pending the passing of Bill C-86. Until this legislation is passed, our status remains in danger of being revoked. We urge the committee to support the passage of Bill C-86 and to affirm the critical importance of allowing charities like ours to engage in public policy dialogue without fear of harassment or loss of charitable status in pursuit of our charitable purpose. Thank you for your time.